Have you ever wondered how Louisiana law defines a person, or how the law affects family relationships and adoption? Chapter 12 of the 2025 Fundamentals of Louisiana Notarial Law and Practice contains too many insights into these topics to cover in one video, so we will be breaking this down into separate videos. This video is the first of 3 videos on the chapter titled, Of Persons, the Family, and Marriage. Let's first identify persons. As defined in Louisiana Civil Code Article 24, Louisiana recognizes 2 types of persons, natural and juridical. Natural persons are human beings, and juridical persons are entities like corporations or partnerships treated separately from their members. Civil Code Article 25 explains that natural personality starts at live birth and ends at death. Interestingly, however, Civil Code Article 26 goes further in defining unborn children, from conception, are considered natural persons for their own interests, such as inheritance rights. But if the child is born dead, the child is considered as never existing as a person, except for purposes of actions resulting from wrongful death. A juridical person, unlike a natural person, is an entity to which the law attributes legal personality. This category includes corporations, partnerships, and limited liability companies. These entities can own property, engage in legal transactions, and even sue or be sued. Crucially, a juridical person's personality is distinct from its individual members. Juridical persons must act through representatives authorized by law or their governing documents. Unincorporated associations can be treated similarly if members transact together or authorize representatives explicitly. However, a community property regime between spouses does not form a juridical person. What is domicile? Now that we've covered persons as defined by Louisiana civil law, let's next cover domicile. This is the habitual residence of a person. A natural person may reside in more than one location, but must have only one domicile at a time. Understanding domicile is critical as it influences jurisdiction for legal actions, inheritance, and marriage. In the case of spouses, each spouse may have either a common domicile or separate domiciles, depending on their individual circumstances and intentions. Louisiana law acknowledges that spouses may choose to maintain separate domiciles based on their unique situations. The domicile of an unemancipated minor typically aligns with the domicile of their parents or the parent with whom the minor habitually resides, unless otherwise ordered by a court. For minors under tutorship, the domicile generally aligns with that of the tutor. For example, minors have the domicile of their parents, while married individuals may have separate or common domiciles. A natural person can change domicile by physically moving their habitual residence and demonstrating an intent to make that new place their permanent home. Civil Code Article 44 specifies that domicile is maintained until acquisition of a new domicile. A natural person changes domicile when he moves his residence to another location with the intent to make that location his habitual residence. A change in domicile may be evidenced by a sworn declaration recorded in the parish records of both the former and new domiciles. Importantly, this declaration provides strong, though not conclusive, evidence of a change in domicile. This is further elaborated in Civil Code 45 stating, proof of one's intent to establish or change domicile depends on the circumstances. A sworn declaration of intent recorded in the parishes from which and to which he intends to move may be considered as evidence of intent. Again, this means the declaration proves intent but is not conclusive. Domicile affects legal decisions in family matters, succession rights, and jurisdictional issues, making it an essential concept to understand clearly. Next, let's discuss filiation. Filiation establishes the legal relationship between a parent and their child, serving as the foundation for rights such as inheritance, support, and parental authority. Under Louisiana law, filiation can arise naturally, through adoption, or by legal acknowledgement. Natural filiation is typically proven by a child's birth to their biological mother. For the father, presumption of filiation is defined in Civil Code Article 185. That is, filiation or paternity is presumed if the child is born during the father's marriage to the mother, or within 300 days following its termination. If the father is not married to the mother, filiation requires formal acknowledgement or judicial action. Acknowledgement of paternity can occur through an authentic act declaring that the signer is the biological father, or through the signature on a child's birth certificate. Additionally, when disputes arise, such as when there's disagreement between the presumed biological father and another party, a three-party acknowledgement can be completed, specifying the true biological parentage, which is then recorded officially. Additionally, per Civil Code Article 197, Louisiana law also allows for a prescriptive period, specifically a time limit within which a child or representative can initiate a legal action to establish filiation. For instance, a child may file an action to establish paternity within 1 year of the alleged father's death, and failure to act within this time frame means the claim is barred. Moreover, the law provides for a presumption of paternity or maternity in cases of adoption. Once an adoption is finalized, the adoptive parents assume the same parental obligations as natural parents, severing all previous legal ties with biological parents. Louisiana even allows adult adoption under specific conditions. Let's talk about this next. Adult adoption under Louisiana law enables the creation of a legal parent-child relationship even after the adoptee has reached the age of majority. While most adoptions are governed by the Children's Code, adult adoption is distinct. It may be accomplished either by a judicial process or before a notary public, depending on specific circumstances. An adult may be adopted through a judicial adoption if there are contested matters or if the situation otherwise requires court involvement. However, Louisiana uniquely provides a simpler procedure through an authentic act of adoption, allowing the adoptee and the adopter to establish their legal relationship before a notary, provided that certain conditions are met. Under this authentic act, if the adopter is married, the spouse of the adopting parent and the spouse of the adopted adult must both concur explicitly by signing the act of adoption. Without this concurrence, the act cannot legally create the adoptive relationship. Conversely, if the adoption is completed through a judicial process, the consent or concurrence of these spouses is not mandatory. Moreover, the adult adoption can legally change the name of the adopted person. When performed through a notarial act, the new name can be explicitly designated in the adoption document. In cases where the adoption occurs judicially, a separate official birth certificate can be obtained, reflecting the new legal name of the adoptee. To alter one's name on official state records like a birth certificate, additional documentation, including a certified copy of the adoption judgment or the notarial act of adoption, coupled with an affidavit of no objection from the district attorney, is required by the Office of Vital Records. Additionally, the act of adult adoption must be recorded officially with the clerk of court, becoming effective upon filing. This filing ensures the legal adoption is publicly recognized, giving full force and effect to the newly formed family relationship. Adult adoption thus provides a meaningful pathway for formalizing bonds that, although developed later in life, carry all the legal significance and rights of natural parent-child relationships. This concludes part 1 of our review on this chapter and should provide you with a solid understanding of Louisiana's civil law regarding identification of persons, domicile, filiation, and adult adoption. But don't stop here. Be sure to like, subscribe, and hit the notification bell to stay updated when I drop the video for part 2 and for more chapters from the 2025 Fundamentals of Louisiana Notarial Law and Practice. If you have questions or topics you'd like to see covered next, drop a comment below. I love hearing from you. Thanks for watching, and I'll see you in the next chapter.